Good afternoon, everyone. Thank you for attending today's webinar on Proposition 64, presented by Eric Kasher and Alex Mogg. A couple of housekeeping items. First, all of your telephone lines are muted. You should have if you'd like to ask a question, you should have a Q&A box at the top of your screen. Please type your question in this box. Eric and Alex will answer all questions as they come in, but keep in mind we have a lot of folks registered for today, so if your question isn't answered, Eric or Alex will follow up after the webinar. We are offering CLE credit for this webinar. If you check the box on your registration form to receive credit, a CLE form will be emailed to you. We will also email the slides to all attendees early next week. Now to introduce our speakers, Eric Kasher and Alex Mogg. Eric Kasher has been assisting public and private clients with legal and regulatory matters throughout California for nearly 10 years. His comprehensive experience ranges from public law and public contracting to construction litigation, workplace investigations, and public-private partnerships. Eric has a particular focus on the broad range of challenges that government agencies, cities, counties, and special districts face as they implement their mandates and missions. Eric is also General Counsel for the East Bay Dischargers Authority and a Commissioner with the California Fair Political Practices Commission. Alex Mogg is an associate with the Municipal and Special District Law Practice Group. Alex's practice focuses on public law matters related to economic development, municipal finance, code enforcement, and land use. He has assisted multiple municipalities in drafting marijuana-related ordinances and regulations, so we are in great hands for today's webinar. That's all for administrative matters, and I will now hand it over to our presenters.
Great. Thank you, Christine.
Thanks. Good morning. Good afternoon, I guess. I'm Alex Mogg.
Eric Kasher. Glad to be here with you guys.
And I just wanted to start by doing a quick overview of what we will discuss today. First, we'll do a brief overview of the regulatory structure of Prop 64, also known as the Adult Use of Marijuana Act. And we'll touch base and sort of give an update on the status of state regulations. We'll then talk about some of the issues related to local regulation, and then address some of the still outstanding issues that the new Trump presidential administration raises and what impacts the change from Obama to Trump might lead to. And finally, we'll briefly touch on some of the common issues that different jurisdictions are facing as they tackle the marijuana issues. So Prop 64, the AUMA, creates a regulatory structure for the commercial and non-medical use of marijuana. Generally, it's very similar to the structure that was created for medical marijuana last year by the legislature when they adopted the Medical Cannabis Regulation and Safety Act. The Department of Marijuana Control is the lead agency overseeing the implementation of Prop 64, and they are contained within the Department of Consumer Affairs. And you might recall that originally when the legislature passed the medical marijuana last year, they created an agency at the time called the Bureau of Medical Marijuana Control. Regulation Control. They have renamed that in the past the Bureau of Medical Cannabis Control, and now again Prop 64 renames that the Bureau of Marijuana Control. And that is the lead agency for implementing Prop 64. As you may be aware, Prop 64 creates about many different types of licenses for commercial activity, 19 different types, in fact. And the responsibility for who is responsible for licensing and creating regulations is spread out between a couple of different agencies. The Department of Consumer Affairs, they are in charge of transporters, retailers, distributors, and micro businesses, which is a new category that Prop 64 created. The Department of Food and Agriculture is in charge of cultivation and the track and trace program. And then the Department of Public Health supervises manufacturing and testing. And a common question is, what is manufacturing? That has to do with the extraction of marijuana or the production of edibles, foods and drinks, that sort of stuff. And also, in addition to what's listed here, the Department of Food and Agriculture has some responsibilities for working with environmental agencies to work on regulations related to water and water diversion and clean water. So that is a very basic overview of the structure of Prop 64, the structure Prop 64 creates, and the licensing scheme. Under Prop 64, as I just mentioned, different agencies are assigned responsibilities, and they are entrusted to come up with regulations. And under the law, state licenses are to begin being issued on January 1st, 2018. As of now, there are still no regulations to implement Prop 64 in the AUMA. In particular, the head of the Bureau of Marijuana Control has indicated that draft regulations will be developed in the next 3 months, released in the next 3 months, sometime in April is the goal, but that's to be seen whether that is the case. The state agencies are frankly pretty far behind on where they hope to be in developing these regulations. The director has indicated, the director of the Bureau of the director of the Bureau of Cannabis Regulation has indicated that they probably are going to have to use an emergency, the emergency regulation process to get these up to date and in place by January 1st. You might have heard that recently, just a couple of days ago, the legislature, in fact, had some hearings on the status of these regulations because they are very concerned that this will not be in place by January 1st, 2018, as required by the law. And the latest update is that the state will have the regulations in place certainly will have the regulations in place for medical marijuana by January 1st. They will also, whether through using emergency procedures or the regular process, will have the non-medical, the commercial regulations in place by January 1st, 2018. But it is unlikely that they will be issuing non-medical, recreational, commercial licenses in a large scale on January 1st, 2018. So that means, in essence, that not everyone who's applying for one of these licenses is going to have a license on January 1st, 2018. It's going to take some time to get those licenses issued. And that's important because it is, under Prop 64, it is illegal to operate without a state license. So no one should be operating without a state license. Entities that operate commercial, cultivation or engage in other activities without a state license risk criminal penalties, and also they risk being disqualified or at least put at a severe disadvantage for getting licenses once the state begins to issue those licenses. So one thing to keep in mind is that means that localities don't need to act immediately. They have time to develop their own, as Eric will talk about, their own local regulations, and there's not an immediate rush to get those in place. Just some additional information. The governor, in his proposed budget for the upcoming fiscal year, has proposed around $52 million to implement these regulations. That is, it's good that money is there, but that's a relatively small amount of money for creating a brand new regulatory scheme for a potentially multi-billion-dollar industry. And I bring that up just to mention the fact that state agencies are, going to be operating very slowly. There's going to be hiccups. Things are going to take longer than they say they will. I believe on a previous webinar, one of my colleagues mentioned that the state should have its new website up with lots of brand information by sometime in January. January has come and gone. We're now in February, and if you go onto the state's website, it still refers to itself as the Bureau of Medical Cannabis Regulation, which is an agency that doesn't even really exist anymore. So it's going to take time to work through all of the issues. Although these agencies will be coming up with detailed regulations, the AUMA itself does have some standard regulations in it. For example, it sets up that licenses should be issued for 1 year, that they are renewable annually, that certain large-scale cultivation and licensing won't be issued until after 2023. That the law also creates a preference for those residents and those entities who have lived continuously in California since January 1st, 2015. And another requirement that no one can get a license to is also a retailer of alcohol and tobacco. So those are just some of the examples of requirements and provisions that are in the statute itself. But many more regulations will be coming from the state about how these businesses are to operate. And as I mentioned previously, the state, the Bureau of Cannabis Regulations, anticipates the draft versions of those regulations being available in sometime in April. And hopefully that will be the case, but we'll have to wait to see if that's a reality.
Great. Thank you, Alex. Let's flip to the next one. Excuse me. Okay, so we have our first question. I think I'll take an opportunity to answer that. This is Eric here, because it dovetails and it transitions well into the area that I'll be covering, which is the role of local approvals. And so the first question is, did Prop 64 change any rules regarding smoking marijuana in public? And the answer to that is, under the ballot initiative, the ballot measure, smoking marijuana is still banned from, you still cannot smoke marijuana in public places unless it is allowed by a local ordinance. And there's a few other items I wanted to mention that are important to note. Additionally, marijuana cannot be smoked in places where state law already prohibits tobacco smoking, and that also includes restaurants and theaters. The measure includes a ban on smoking marijuana within 1,000 feet of a school, daycare center, or youth center. And then also, as we all know, please do keep in mind that there are still penalties for driving, smoking under the influence, driving under the influence of medical or of marijuana. So be mindful of that and advise folks that if you're smoking marijuana when operating a motor vehicle or boat, that's something that you will still be, responsible for.
And just one thing to add, the Prop 64 itself does not provide a definition of what constitutes public. You can sort of piece one together by looking at other places of the Health and Safety Code, but Some jurisdictions have taken it upon themselves to adopt an ordinance defining that for their jurisdictions, just so there's no confusion about what is a public space where marijuana smoking is prohibited.
Thanks, Alex. So I'm going to talk a little bit about, what are the local controls that are available? I know a lot of your clients, your agencies are wondering, this proposition has gone into place. Recreational marijuana is the law of the land. What are the things that your boards, your councils, your agencies can do to place some restrictions and regulations on the recreational use of marijuana? So one of the things to keep in mind in where some of the issues exist is that under the prior law related to medical marijuana use in dispensaries, there was a requirement that before you could obtain a state permit for a medical marijuana dispensary, you needed to first demonstrate to the state that there were local approvals in place that allowed for that medical marijuana dispensary. Under the new Proposition 64, no documentation is required of local approvals before you obtain a state license. So you can imagine the types of situations that might exist where you might have a local recreational marijuana dispensary that applies for a license from the state and obtains it, even though the local agency has an ordinance in place that prohibits medical marijuana or recreational marijuana dispensaries. And so you might have a dispensary that decides to open up shop. They say, hey, we have a state license, and there's a legal issue that's created there. And I'll get into this more on the next slide, but one of the ways to avoid that type of situation is to very clearly set forth in your zoning code or your ordinance, or adopt an ordinance that explicitly places regulations on the types of recreational marijuana activities that you would like to regulate. But just wanted to throw that issue out there because there is this difference where the burden is actually on the state under the prior law, but under the new law there haven't been there's nothing in there yet that requires that the state verify the local approvals. Now that's creating a lot of discussion amongst the folks who are working on these issues. I know the League of California Cities is very active in working on regulations that will help to correct and clarify these particular issues. And there likely will be new legislation that will be adopted and pushed forward to help to clarify this, that would allow, for example, a statewide database of all of the local ordinances for all the various local agencies, so that if there is a recreational marijuana dispensary or commercial enterprise that applies for a state permit, the state would have the ability to then cross-reference with the local agency's ordinance to determine whether or not it's a permitted activity within that local ordinance, that local municipality. But those regulations have not been adopted yet. There's still work that needs to be done on that particular issue. So I also wanted to talk about the various ways in which a local agency can go about regulating recreational marijuana. So local agencies, and this is directly under Proposition 64, local agencies have the ability to prohibit or allow any of the operations provided for in Proposition 64. However, the local agency must adopt an ordinance to that effect. So, for example, if your agency wants to allow for non-medical marijuana businesses, but ban, for example, outdoor grows, we would strongly recommend that the local agency adopt an ordinance to that effect, and very, very clearly setting forth, what is allowed and what is not allowed in your particular jurisdiction. Another example is if your agency is interested in allowing for the sale of non-medical marijuana, but banning the manufacture of marijuana-related products, that's another situation where we feel like an ordinance would be useful to clarify that particular regulation. And in Prop 64, and in particular the Business Code, Alex mentioned this, there are 19 different licenses that the state will issue related to various types of recreational marijuana activities. They range from cultivation indoors, cultivation outdoors, mixed lights, cultivation nurseries, manufacture of marijuana-related products, retail enterprises, distribution enterprises, micro businesses, testing. There's companies and there's licenses that are available for those who are just in the business of testing marijuana-related products. So I would encourage each of the agencies to take a look at the various licenses that the state will likely issue and see whether or not it makes sense to have some sensible regulations within your agency on those specific issues. The last point that I wanted to mention, and this relates to the issue of permissive zoning. Many local municipalities and many of my clients have what's called permissive zoning, and I think most of you are familiar with. It's essentially language in your zoning code that says that any activity that is not explicitly referenced or mentioned in the zoning code is not a permitted use. And that will ultimately, that's something that's defensible, and a lot of agencies rely on that. I would recommend, and Alex, you let me know what your thoughts are, but if your board and or your council feels strongly about adopting regulations on the use of property, I would recommend they explicitly reference these particular issues in your zoning code or adopt an ordinance, because you don't want to be in a situation where you're relying on a permissive zoning type of language where the state is issuing a license and someone's running into court saying, hey, I have a state license. I appreciate that there's, that it's a little bit unclear because there's this permissive zoning ordinance, but it doesn't explicitly say that recreational marijuana sales are prohibited. So if there is an interest by your agency to take those types of measures, I would strongly suggest dropping that into your zoning code and adopting an ordinance to that effect. So the next slide here, so the takeaways that I wanted to just leave you with on those particular issues, it's important to be, on these particular issues related to Prop 64, it's really important to be proactive with the regulations. One of my clients has indicated that they would like for us to agendize a Proposition 64 in the form of a study session where we could bring before this particular council some of these issues that are created, some of the differences in the law between the state and the local law and the local agency's ability to regulate, and conduct a study session where we could hear from our council so we could get guidance from our council on some of the areas that they may want to regulate or that they may want to permit. And so that's something that we plan on doing, and that way we can have some guidance and some direction from our council on how they would like to move forward with any ordinances or regulations. That way they have the ability to offer some input, and as Alex mentioned earlier, there is time to do so, because a lot of these don't go in, a lot of these requirements are not going to go into, most of them won't go into effect until January 1 of 2018, so there's time for our agencies to convene these meetings, have these conversations, and then adopt sensible regulations to the extent that they would like to account for this. There's an open issue as well on whether or not the state will allow for the sale or transfer of existing licenses. You could imagine the issues that arise where you have let's call it a recreational marijuana dispensary that obtains a state license, and maybe they go out of operation, shortly thereafter, and they're then in the business of selling or exchanging that license. What impact does that have on your locality where there's a transfer? Again, just raising issues here. And then there's one bullet point that's not on here, but I'd be remiss not to mention as a commissioner for the FPBC, the Fair Political Practices Commission actually has weighed in on marijuana issues, and they have issued for the first time 2 advice letters related to medical marijuana. They didn't want to let these other state agencies have all the fun, so they had to weigh in and offer some opinion on this. And as you know, the Fair Political Practices Commission has jurisdiction over both the Political Reform Act and Government Code 1090. And one of the advice letters that was published in December addresses the question of whether a council member may enter into a private partnership through which he or she will seek a permit for marijuana cultivation. The FPPC opinion on that, applying Government Code 1090, says that the council member would not be prohibited from entering into the partnership. However, the Political Reform Act would require that the council member not participate in the making or influencing of any decisions related to the approval or issuance of that permit. So if that council member who had a partnership in a marijuana dispensary had a permit that came before them while they were on the dais, the FPPC says that council member would need to recuse themselves and not take a position or vote on that particular issue. So if you have an interest in looking into those particular advice letters, they're available through a search on the FPPC's website. If you just type in marijuana in their advice letters, there's only 2 letters that come up because these are the only 2 that they've dealt with. And federal regulations.
So as you are all very much aware, there is a new presidential administration, and there is some question of how this administration will treat both medical marijuana and marijuana. So just an overview to understand where we are today. The Department of Justice back in 2009 issued a memo that basically instructed federal law enforcement agencies to not focus on those individuals whose actions were in compliance with existing state laws regarding medical marijuana. And this was specific only to medical marijuana, and it instructed really that prosecutors should focus on significant drug traffickers and the disruption of drug manufacturing. And obviously, local U.S. attorneys interpreted this all on different scales, and some were more aggressive than others. But in general, there was this overarching federal memo, this instruction. Later, first in 2011, the Department of Justice sort of walked it back a little bit and wanted to clarify that 2009 memo was not intended to give anyone protection who was engaged in illegal acts. It was just a sort of way to prioritize how resources would be allocated, but not to give anyone protection who was operating illegally. Then in 2013, after Amendment 64 in Colorado was passed, and Initiative, I believe it's 205 in Washington, that established recreational marijuana, the Justice Department issued another memo, and that memo stated that the individuals and entities and jurisdictions engaging in certain behavior would be receive low priority status for federal marijuana enforcement. And there were 4 goals that were identified in order to receive this status. First, preventing the distribution of marijuana to minors. Second, preventing revenue from the sale of marijuana from going to criminal enterprises, gangs, cartels, other things like that. Number 3, preventing the diversion of marijuana from states where it is legal under state law into other states where it's not legal. And 4, preventing state-authorized marijuana activity from being used as a cover or a pretext for trafficking other illegal drugs or engaging in other illegal activities. And, along those lines, other issues were identified, like preventing violence and the use of firearms in cultivation and distribution of marijuana. And that is the status that we are at right now. Although, as it says on the slide, in the second half of the Obama administration, with the 2013 Cole memo, there was a fairly lax attitude towards marijuana on the federal level. But the Obama administration never was in favor of federal decriminalization of marijuana or of rescheduling marijuana as a narcotic. And that brings us to today. And the Trump administration has given, or members of the Trump administration have given sort of wide-ranging statements on how they treat marijuana, and there's not a clear policy yet. Many of you may be aware that the nominee for Attorney General, Jeff Sessions, has in the past stated a very strong dislike for medical marijuana and sort of has suggested a more aggressive approach to treating marijuana. In contrast, over the years, President Trump has expressed, varying degrees of support. In the early 90s, he is on record as being totally in favor of marijuana legalization. More recently, during the campaign, he expressed some hesitation about recreational marijuana legalization, but that he was comfortable and in favor of the idea of medical marijuana, so that sick patients could have access to this. So it's still sort of uncertain how the Trump administration might treat this issue going forward. One thing, the rumored nominee to be administrator of the Food and Drug Administration is an individual who in the past has supported rescheduling marijuana from a Class 1 narcotic. So that's just an example that some of these issues are still outstanding. Obviously, these are probably not the administration's top priorities, so it might take some time before they issue guidance. And it's important, if you're going to move forward with marijuana activities in your city or to operate a marijuana entity, that you are aware of what these what these possible options are.
Yeah, thanks, Alex. And I just wanted to point out, because it was, here locally, it was really interesting how the federal government was treating medical marijuana, because you did have this memo that was issued by the Obama administration and Eric Holder, the Attorney General, but we had a local U.S. attorney, Melinda Haig, who had control over the DOJ office locally, and she pursued litigation against Harborside, as many of you know, which was a dispensary in Berkeley. The litigation predated the memos that the Obama administration and Attorney General Holder issued, but then even after those memos were they came out, she continued to pursue litigation against Harborside, which was a dispensary that I think many regarded as one of the more ethical dispensaries that were around. So it raises this really interesting issue of, even though there are these mandates and or orders that are being issued by the Attorney General or at the executive level in the federal government, there is still some discretion for local U.S. attorneys in how they go about prosecuting matters related to recreational and or medical marijuana issues. And I'll maybe take a chance to answer one of the questions that we received as well, because I think this somewhat relates. The question is, given the new federal administration and potential renewed efforts to enforce the Controlled Substances Act, what is the potential exposure to public officials and employees to either criminal or civil sanctions for facilitating the business of cultivating, selling, distributing, or using non-medical marijuana through the adoption and implementation of related ordinances? I think that's a really good question. I think it's something that should be discussed and considered for local agencies that are looking to have permitted recreational or medical marijuana dispensaries and or uses. I think that's an open legal question at this point. I would think that there's some government immunities that would apply and that certainly can be raised as a defense, but And certainly I don't think there's anything on the federal level at this point that would provide for that type of an action to be brought against a public agency or employees. But we have a new administration, and there are executive orders that are flying around, as you've seen, and it's unclear at this point to what extent they intend to crack down on these types of operations. And so we're going to be closely monitoring this, and we'll be providing updates, through client alerts to all of our clients. But this is something that we're going to be monitoring closely. I don't know of any cases out there where there is a local agency that's faced those types of charges, but this is a very different set of circumstances that we're now in with the new administration.
And certainly it's possible to imagine that even if public officials weren't sought after for enforcement, that the individuals themselves who were operating these businesses could face criminal enforcement. And just so everyone is aware and needs to be thinking about these issues, that the full range of issues, the full range of options for how the Trump administration might deal with marijuana ranges from, going back to days of raids and seizures on those who are cultivating marijuana, selling marijuana, potentially using other legal tools to seize property that is related to marijuana cultivation. At the other end of the scale, perhaps there's legalization of marijuana going forward, or an attempt to do it on a national scale to get some of those anticipated tax benefits into the federal government. There's also the option of status quo, that things will just continue in place, at least in the near term. Or I've seen some discussion that perhaps a likely way for the administration to be more crack down on marijuana a bit more than was the case in the latter years of the Obama administration is to simply enforce the Cole Memo. So as I mentioned, the Cole Memo states that in order to receive this low priority status, there needs to be compliance with these 4 goals. And it's not out of the question that the administration could look at places that don't comply with those 4 goals and start going after those places, start enforcing against those entities and those jurisdictions. And I think that is one thing to keep in mind as if you're a local jurisdiction, as you adopt your ordinances and regulations. If you require each place, each entity that's going to open as a business to have submit a safety plan and to submit, plans for how they're going to account and audit for all of their money, that's a much stronger argument that you are complying with the Cole Memo and should deserve low priority status than if you sort of just say, come in for a business license, the first 4 people who show up and pay the fee are going to, win the license. So it's just important to be aware of that as you prepare and draft your regulations and ordinances.
Okay. Banking. This is a very important topic because a lot of local agencies, understandably so, are very interested in the sales tax revenue that stands to be generated by the sale of recreational marijuana. So I'll just set the issue up a little bit, and then I'll talk a little bit about some of the work that's being done in this regard. As we all know, the federal government still considers marijuana a Schedule I drug under the Controlled Substances Act. And as a result of that, banks and other institutions generally refuse to provide services to cannabis businesses. At this time, 70% of marijuana-related businesses do not have bank accounts for that very reason. However, the state is expecting close to $6.6 billion in a projected increase in cannabis sales in the state of California by the year 2020. Proposition 64 obviously imposes a 15% tax on retail sales of cannabis. And so by taxing cannabis, California is expected to bring in an estimated $1 billion in tax revenue just at the state level, and that's not including the various types of sales tax measures that might be implemented locally. And so this creates this issue of medical and recreational marijuana sales in dispensaries who are processing and who are involved in the activity of sales and who have significant amounts of money that are flowing through these organizations that need to then be paid to the local government or the state government. But you don't have banks like Wells Fargo and these larger institutions that are subject to the federal regulation willing to accept their money. And so there's an effort that's taking place at the state level that's called the Cannabis Banking Working Group. And this is an organization that has been adopted by that's convened by the state treasurer, John Chiang, and he has convened a group that is made up of a lot of interested parties. They have representatives from the banking industry. They have representatives from the California Board of Equalization and various state agencies that are impacted. There's representatives from the Bureau of Medical Cannabis Regulation and other interested parties, and they are discussing this issue and all the various options that might be available to, for example, set up a state or local kind of banking structure where some of these amounts, this money can flow through. Because again, how does this money get to the state? Where are these payments made? How does this money flow to the local governments? And where are these payments made if it's not a transfer of money through a bank account? So that organization has been formed. They actually have a meeting they have a website that you can check out, and they actually have a meeting that's agendized for, I think, February 10th. So if you're interested in learning more about what's taking place with that particular effort, feel free to search their website and maybe even attend their meeting. In addition, there's a new piece of legislation that has been put forward by Senator Scott Wiener and Tony Atkins, which is a bill that would simplify the way that cannabis businesses in California pay taxes and fees. That's called the Cannabis Safe Payment Act. It's a proposed piece of legislation that I'm not sure exactly where it is in committee at this point, but the idea is that it would allow cash payments at many more locations than are currently available. The idea being, if you have a dispensary in your locality, they don't have to drive or take a huge van full of cash to the state capitol in Sacramento to make these payments. Let's figure out a way for them to make these payments responsibly in a local place, so that you don't have to, your law enforcement won't have to deal with the issues of crime and related to maybe trying to stop those vehicles. So this would create more locations locally. This bill would do that, and it would also adopt a structure whereby fees can be paid through local county tax collectors if they decide to participate in that, which would, again, assist in the ability of these marijuana dispensaries and the commercial sales to pay their taxes to the state and then the local entities. And then the last bullet point relates to options for local jurisdictions. This is something that, again, this might be an issue that arises in a study session for one of your board or your council, or maybe just discussed amongst city staff. But if you are going to allow for commercial sales of recreational marijuana in your jurisdiction, how many are you going to allow, and what is going to be the process for those dispensaries or commercial enterprises to make payments, sales tax payments to you as a city and or an agency? So give some thought to that, because there is this restriction on banking, which makes it a little difficult when you are thinking about the amounts of money that will be exchanging hands in these various transactions. And other common issues.
And so lastly, we're just going to touch on a few common issues that we have heard have come up in various jurisdictions from the point of view of individuals who are trying to operate or looking to operate marijuana entities, and also jurisdictions who are looking to regulate these issues. And as I mentioned briefly before, the state is issuing licenses, the state will be adopting regulations for those licenses, and it's a requirement that all entities have those local licenses, and, those state licenses. And a question that often arises is, do local jurisdictions have the ability to enforce those state licenses and to make sure that entity that's operating within the jurisdiction is complying with the requirements of the state license? And generally, as a baseline, that answer is no. The state is best to regulate those. But the AUMA does provide that the local agency can be delegated the authority to enforce the AUMA's regulations. They'd have to enter into an MOU with the state agency. And this is a way to ensure that the provisions of the AUMA are actually enforced, because this is potentially a huge issue, a huge industry, and question how much enforcement, especially of minor violations, state agencies will be able to do. And the other issue that comes up frequently is what to do about local criminal penalties and criminal enforcement. And there's a tendency for local jurisdictions, I think, when they're adopting regulations and ordinances and deciding how much they want to allow in their city, to simply say, well, if there's any bad actors who, are violating our ordinances or violating state law, there will be criminal enforcement, and that will be a deterrent against them. But we've heard somewhat frequently that district attorneys are getting less and less likely to enforce criminal violations of marijuana laws. And that, we've heard, is because both that penalties have been decreased through the AUMA and other laws, and also it's just no longer a political priority to enforce those ordinances, those state laws, And this is true. I know of a few examples where this is true, even for fairly significant violations of large illegal grows, where a district attorney has just decided it's not worth his time an effort to try and enforce against that. And the reason I bring these two up as common issues is, again, sort of a theme that's been mentioned a couple times in this presentation, is local jurisdictions really need to be proactive. They cannot rely on the state to enforce laws. They cannot set up a system and assume that the district attorney or the sheriff or whoever will enforce it. They really need to make sure that if their system they're putting in place is enforceable on the local level. And two other common issues is the possibility of over-concentration of marijuana in localities. A lot of localities really want they envision themselves, as becoming centers of the marijuana industry. I think especially a lot of, there's huge cities like LA that are, billion-dollar industries all by themselves. But other small cities envision this might be a big economic engine for our area if we can be the place in our county that has marijuana businesses. And, that brings up a couple issues related to, if different cities are fighting against each other and offering benefits, as you see with car dealerships sometimes. That's not great for anyone, and there's been some jurisdictions in some cities, in some counties, are in the preliminary stages of trying to work out sort of regional or county-wide regulations, so it's uniform across the county and that there's one county tax, so that this tax money is shared across the county, and so there's no longer as much incentive to fight against each other for these businesses. But the other issue that oversaturation presents is that under the AUMA, a state licensing authority can deny a license to an entity if it will result in excessive concentration. In excessive concentration, one way they define that is if the ratio of a license to population in a particular census tract exceeds the ratio of licenses to population in the county as a whole. And this is something to keep in mind because it's easy to see a situation where a small city might say, we want to be the focus of this industry, and we're going to allow 6 or 7 cultivation businesses to get licenses to operate locally, local licenses to operate in our town. But then when those 6 or 7 licensed businesses go to the state to get their required state licenses, the state determines that really this town should only have 4 businesses in it because of overconcentration. And then the city is in the place of having to decide which one of those 7 businesses gets the local licenses. And that can just create a huge headache, especially if these local businesses have maybe already paid fees to the city. It's just it's a problem that can be avoided by just taking time and going slowly through creating these local ordinances and these local regulations. And the last issue is perhaps the most common question I'm asked, is whether prohibiting outdoor growing of plants or retail sales prevents local jurisdictions from getting grant money from the state. And the answer is yes. Under the AUMA, there is a pool of money that is set aside for local agencies, but those agencies are not available to get it if they have banned cultivation, including personal cultivation or retail sale of marijuana products. The one thing I would mention is this Prop 64 sets up a lot of different entities that are going to get money, and this local grant money for local entities is rather far down the list of priorities. So at this point, it's not clear how much money that will be. If it ends up that there's tons of tax revenue and cities are missing out on a lot of grants, they can always change their ordinance in the future. And given the new administration, it's also not impossible to imagine a situation where cities who have banned marijuana cultivation and retail sales are given priority for certain federal law enforcement grants over jurisdictions that allow that activity.
And I'll just add, and I think that's a really good point, Alex, on the last one. Something to keep in mind: if your local agency has a federal grant or a federal loan that may be tied to a public works project or something completely unrelated to recreational or medical marijuana, it's not out of the realm of possibility that the new federal administration, the executive office, may take the position that an agency or a state that allows for recreational use of marijuana in violation of the Controlled Substances Act might jeopardize their ability to receive federal funding because of that. So that's obviously nothing that's been directed yet, but again, we're going to be in a wait-and-see approach to that, and we want to closely monitor what's coming out of the federal government to see how they're going to, what ways in which they might impose regulations on states and local municipalities.
And so one question I see that has come in is, what are the drawbacks to addressing commercial marijuana uses in your city's business license code section rather than the land use section? And generally, I would suggest putting these regulations in the land use code rather than just the general business license section. The land use code, putting in the land use code really makes it clearer for prospective businesses what uses are allowed and what uses are not allowed, and it also is likely the place the state is going to be looking to first. And part of the reason for that is when the state adopted its medical marijuana rules last year, there was a provision in that law requiring cities to put their requirements within either adopt them as the land use ordinance or put them within the land use code. And so many cities have adopted rules regarding medical marijuana in the land use code of their cities, and it would be quite weird to have, Prop 64 does not require cities to adopt their regulations in their recreational marijuana regulations in the land use code, but it would be quite strange if a city had its medical marijuana regulations in the land use code, but it had its recreational marijuana regulations in a different section of the code, in the business license section. So for consistency's sake, I would say generally best to put it all within land use code.
And we have just one other question in this, and I'll read it out. Can local entities prohibit public safety employees from using recreational marijuana off-duty? If not, are there minimum standards set regarding what is under the influence in terms of impairment? And then as a follow-up question, with impairment on duty, what are the rules around whether or not employers can test for drug tests, essentially, their employees? And I wanted to indicate that question is a little bit out of my area of expertise, but the chair of our labor and employment group, Gina Rokanova, did a presentation, a webinar on this very issue, and dealing with these kind of new and interesting issues of the use of marijuana by employees and or in the workplace. As a general matter, the general guiding principle is that there is quite a bit of discretion for employers as long as they adopt a very clear policy regarding the testing of marijuana and when individuals will be tested. There's concerns. You can't be seen as targeting an employee because that could create kind of civil rights issues. So and then there's also a lot of issues around the testing for marijuana, because if you get tested for marijuana, it can stay in your system for several weeks, and so an employee may no longer be impaired by the use of marijuana, but that might still show up in his or her system. So there are issues around that, and what is the accurate measure for testing, and I think the technology is still advancing on those particular issues. So we are going to send around a link to the webinar that Gina did on the employment-related issues. I just wanted to indicate that was a good question, but you'll have more information on that in the webinar that we'll send around. And then it doesn't look like there's any further questions, so I just want to thank you guys for your time and hope you found it useful.
Thank you.
Thank you all for joining us today. We will send out CLE forms and slides to you early next week. If you would like a copy of the previous webinar Eric has referenced, feel free to reach out to myself, Christine Gregory, or Stephanie Hill, and we will get that information over to you. Thank you so much.